What is the Office for Civil Rights, and what laws does it enforce? The Office for Civil Rights at the U.S. Department of Justice is responsible for ensuring that recipients of federal financial assistance from the Office of Justice Programs, the Office of Community-Oriented Policing Services, and the Office on Violence Against Women comply with applicable federal civil rights laws. The Office for Civil Rights at the Office of Justice Programs is different than the Civil Rights Division at the Justice Department. Many people are not aware of this distinction and confuse the Office for Civil Rights with the Civil Rights Division. To explain the distinction between the two offices, the Office for Civil Rights is directly connected to the funding components of the Justice Department. This side of the Department of Justice consists of program offices that award federal grants or provide other forms of federal financial assistance to recipients. Another distinction is that the Office for Civil Rights enforces civil rights laws exclusively through an administrative process, whereas the Civil Rights Division often enforces laws through the court system. This training segment provides an overview of discrimination in federally assisted programs and the civil rights laws that the Office for Civil Rights enforces.
The key idea governing the enforcement work of the Office for Civil Rights is that whenever federal funding is involved, there is always a civil rights requirement that accompanies the funding. Congress has passed a number of laws that link civil rights enforcement to the receipt of federal financial assistance. When an agency applies for and then receives federal funding, it agrees to abide by certain federal civil rights laws as a condition of receiving the grant award. The underlying principle is that the revenue that people contribute to the federal government cannot be used in a discriminatory manner in federally assisted programs.
In discussing federal civil rights laws that apply to organizations that receive federal financial assistance, it is essential to understand two important terms. First, the term recipient means an organization or agency that receives federal financial assistance. Examples of recipients include state administering agencies, state and local courts, law enforcement agencies, departments of corrections and jails, nonprofit agencies, educational institutions, faith-based organizations, and other service providers. Second, the term beneficiary means the person who ultimately receives the federally funded services or benefits. Beneficiaries may include participants in programs, such as young adults who attend federally funded after-school activities. Beneficiaries may also include survivors of domestic violence who seek the services of a funded shelter. One might also think of beneficiaries broadly. Beneficiaries may include all of the people in a community served by a funded law enforcement agency. All of the people in the community may receive enhanced police services as a result of Justice Department funding. Recipients may often refer to beneficiaries as their clients or customers. Remember this distinction. A recipient is an organization that receives federal financial assistance. A beneficiary is a person who ultimately enjoys the federally funded services.
Federal financial assistance ordinarily takes the form of a federal grant, but federal financial assistance can be broader. It could include technical support, training or equipment, or facilities. For example, if a State Department of Corrections receives funding from the Justice Department to build a prison, as long as the State Department of Corrections uses the facility for the original purpose of the grant, the facility, which the Justice Department funded, is considered ongoing federal financial assistance. Why is this important? When an organization receives federal financial assistance, the Office for Civil Rights then has jurisdiction to enforce civil rights laws. In the example of the federally funded prison, even if the State Department of Corrections did not receive any funding from the Justice Department after the initial funding for the prison, the Office for Civil Rights still maintains the authority to enforce civil rights laws in connection with the State Department of Corrections for as long as the prison served as a prison. In this example, the time frame could be as much as 50 years or more. Throughout this presentation, we often refer to federal funding, but it is important to remember that federal financial assistance includes more than a grant award.
To understand how civil rights laws work, it is important to understand the idea of a protected class. A protected class is a group of people who benefit from protection by law. A person does not bring a discrimination claim under federal law based on how he or she has been treated as an individual. Rather, the claim relates to how the individual has been denied certain rights based on being a member of a group. At this time, the protected classes in the civil rights laws that the Office for Civil Rights enforces are race, color, national origin, sex, religion, disability, and age.
It is important to pause and think about what some of these protected classes mean. Color, for example, is not the same as race. A person who is a dark-skinned African American may have a claim against an employer who hires only light-skinned African Americans. The claim would not be based on race but color. National origin may include discrimination based on language ability. To comply with the laws addressing disability discrimination, a funded organization may need to modify a program to make it available to a person with a disability.
As courts have interpreted the Equal Protection Clause of the 14th Amendment, they have categorized protected classes by three standards: strict scrutiny, intermediate scrutiny, and rational basis.
It is important to understand that all of the protected classes are not treated the same way under the law.
Race, color, and national origin are at the highest level, often mentioned in legal discussions as requiring strict scrutiny. What this means is that a recipient cannot take race, color, or national origin into account in providing services in a funded program unless there is a compelling governmental interest. Moreover, even if a recipient can show a compelling governmental interest to take race, color, or national origin into account, it would also have to show that the program or policy involved was narrowly tailored and used the least restrictive means.
For example, a federally funded cadet program that a police department developed exclusively for African American use would run afoul of the law if it limited participation in the program based on race. It might be appropriate for the police department to target a particularly underserved population for recruitment in the program, but it would be unlawful for the police department to turn away potential participants in the program based on race.
Sex is the next highest category, often referred in legal terms as intermediate scrutiny. Intermediate scrutiny means that sex can be taken into account when doing so advances an important government interest in a way substantially related to that interest. There are times when it is permissible for recipients to take sex into account in providing services. For example, it is not a violation of federal civil rights laws for a state Department of Corrections to operate separate male and female prisons.
The protected class of religion is not just limited to the membership a person might have in a particular religious group, such as Catholics, Baptists, Jews, Muslims, and Sikhs. The definition of religion extends to any sincerely held moral or ethical belief. For example, if a funded faith-based organization refused to provide services to a person because that person did not share the faith-based organization's views on the death penalty, the person denied services may have a religious discrimination claim if the denial of the services was based on the person's sincerely held moral or ethical belief. Federally funded programs have an obligation to accommodate a person's religious practices or beliefs as long as the accommodation does not impose an undue burden on the federally funded program.
Recipients of federal funding must modify their programs to make them accessible to people with disabilities. The federally funded programs would need to make the changes unless making the change would impose an undue burden or would fundamentally alter the nature of the program. For example, an after-school program funded by the Justice Department might have to provide interpretation services to a beneficiary who is deaf.
When referring to age as a protected class in the context of the laws that the Office for Civil Rights enforces, it is important to understand that the protection only applies to the delivery of benefits or services and not to employment. There is a separate federal law that protects people aged 40 or older from employment discrimination based on age, the Age Discrimination in Employment Act. The Office for Civil Rights, however, does not enforce this law. Instead, the law that the Office for Civil Rights enforces is the Age Discrimination Act, which applies only to beneficiaries of federally funded services. The Age Discrimination Act states that a federally funded organization cannot discriminate in the delivery of services regardless of age, and that can mean any age, whether the beneficiary is 8 or 80.
But it is important to know that when it comes to age, the standard that courts use for assessing whether discrimination occurred is a rational basis standard. As long as a federally assisted program can provide a rationale for distinguishing the delivery of services based on age, the federally assisted program is in compliance with federal law. For example, programs funded by the Justice Department that focus on the needs of juveniles are not discriminatory based on age if the programs can provide a reason for limiting services to a particular age group. Reasons might include that state laws take age into account in criminal sentencing, or that a program is geared to young people at a particular stage of educational or psychological development. Unlike the category of race, where a federally funded program must show a compelling governmental interest for taking race into account in the design of a program, federally assisted programs need only provide a rational basis for designing a program that serves a particular age group. Age requires satisfying only the lowest standard, a rational basis, whereas race requires the highest standard, strict scrutiny.
The federal laws that the Office for Civil Rights enforces also bar retaliation against an individual for bringing a discrimination claim, participating in the investigation of a discrimination claim, or opposing discriminatory practices. It is important to understand that a retaliation claim may stand on its own, regardless of the merits of the underlying discrimination claim. For example, an individual may never be able to prove an underlying employment discrimination claim, but he may be able to prove that he filed a discrimination claim on February 1st. On February 15th, his supervisors moved his office to the basement. On March 1st, he received his first poor performance evaluation after receiving only stellar reviews over the last 10 years. On March 7th, he was moved from all of his most desirable assignments. On March 13th, he received a warning against poor performance, and on April 1st, he was terminated. In this example, the negative employment actions, which follow in close proximity to the filing of the discrimination claim, may be enough to demonstrate that the employer retaliated against the employee for filing the claim. The retaliation claim stands on its own, even if the underlying discrimination claim fails.
In general, there are two ways to prove discrimination under federal law: disparate treatment and disparate impact. To prove discrimination under a disparate treatment theory, the evidence has to show that an individual was a member of a protected class, the individual applied for a job or applied to participate in a program for which he or she qualified, and then the employer either hired a person outside the applicant's protected class, or the service provider denied services to members of the applicant's protected class. Once the claimant can show these elements, the employer or service provider has the opportunity to provide evidence showing that its decisions were based on legitimate, non-discriminatory grounds. Finally, there is the opportunity to challenge the employer's or service provider's explanation by showing that the rationale provided was a pretext for discrimination. To prove discrimination under a disparate impact theory, the evidence would have to show that a neutral law or procedure has the effect of discriminating against individuals of a protected class. A disparate impact claim might involve the use of a test for screening job applicants. If an employer uses a test that excludes a significant proportion of women, for example, in comparison to men, an unsuccessful female applicant may claim discrimination based on sex and challenge the validity of the test. The employer might still be able to rely on the test, but it would have to show that the test was job-related and consistent with business necessity. Even if the employer can satisfy these requirements, the female applicant may still be able to prove discrimination by showing that the employer declined to adopt an alternative employment practice that would have a less adverse impact on women. Disparate impact cases rely on gathering the appropriate statistical data.
The Office for Civil Rights enforces both cross-cutting federal civil rights laws as well as the non-discrimination provision in Justice Department program statutes. Cross-cutting statutes apply to funding that comes from all federal agencies. The program statutes are unique to the Department of Justice.
The Office for Civil Rights enforces the following federal cross-cutting civil rights statutes. These laws apply not only to recipients of Justice Department funding, but also to recipients of all federal financial assistance, regardless of the federal agency that is the source of funding. Title VI of the Civil Rights Act of 1964, Section 504 of the Rehabilitation Act of 1973, Title II of the Americans with Disabilities Act of 1990, the Age Discrimination Act of 1975, and Title IX of the Education Amendments of 1972. Each of these statutes provide different civil rights protections. Title VI prohibits discrimination based on race, color, or national origin in the delivery of services or benefits. Section 504 prohibits discrimination on the basis of disability in federally assisted programs, both in the delivery of services or benefits as well as in employment. Title II of the Americans with Disabilities Act prohibits discrimination on the basis of disability in governmental agencies, and it applies to both services and employment. The Age Discrimination Act of 1975, as we have already discussed, prohibits discrimination in federally assisted programs in the delivery of services or benefits. Remember that this statute does not apply to age discrimination in employment. Title IX prohibits discrimination based on sex in educational programs. Many people are aware of Title IX through the enhancement of opportunities in women's sports.
To understand the civil rights laws that the Office for Civil Rights enforces, it may be useful to look more carefully at the language of Title VI. The non-discrimination language in Title VI is as follows. No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Title VI, as noted previously, prohibits recipients of federal funded programs from discriminating on the basis of race, color, and national origin in the delivery of services or benefits. A key phrase in Title VI is the term program or activity. There was a long legal battle over what this term means. Because civil rights obligations attach to the receipt of federal funding, it is important for a recipient agency to know how far this obligation extends. Does it cover only the project being funded, or does it cover the entire organization? Congress has made it clear that program or activity in Title VI means all of the operations of a funded organization. For example, A Department of Corrections receives federal funding to operate a rehabilitation program in only one of its many prisons. Does the department's acceptance of federal money oblige it not to discriminate only in the funded program, or the entire Department of Corrections, including a prison that did not benefit from the funded program? The answer is the entire Department of Corrections. When an organization receives federal funding for a single project, all the operations of the funded organization must abide by Title VI prohibition against discrimination based on race, color, and national origin.
The regulations implementing Title VI state that Title VI prohibits the following: providing different services to individuals based on race, color, or national origin, denying the opportunity based on race, color, or national origin to participate as a member of a planning or advisory body, which then provides services for federally funded programs, and selecting the location of a facility with the purpose or effect of excluding individuals based on race, color, or national origin.
Section 504 of the Rehabilitation Act of 1973 also applies to all recipients of Justice Department funding. The statute defines a person with a disability, or handicap in the language of the statute, as a person who has a physical or mental impairment which substantially limits one or more major life activities, or a person who has a record of such an impairment, or a person who is regarded as having such an impairment.
Recipients of Justice Department funding should know that the implementing regulations for Section 504 state that a recipient having 50 or more employees and receiving federal financial assistance from the Justice Department of $25,000 or more must do three things. First, designate a Section 504 compliance coordinator. Second, adopt grievance procedures. And third, notified program participants, beneficiaries, applicants, employees, trade unions, and organizations with collective bargaining agreements that the recipient does not discriminate on the basis of disability.
The civil rights protections of Title II of the Americans with Disabilities Act of 1990 apply to public entities regardless of whether they receive federal financial assistance. Public entities that do receive financial assistance from the Justice Department are therefore subject not only to Section 504 of the Rehabilitation Act, but also to Title II of the ADA. The Office for Civil Rights has authority to enforce both statutes in dealing with funded public entities. The implementing regulation for Title II of the ADA states that public entities with 50 or more employees must designate a disability coordinator and adopt grievance procedures.
Under Title IX of the Education Amendments of 1972, recipients of federal financial assistance from the Justice Department cannot discriminate on the basis of sex in educational programs. The implementing regulations of Title IX, like the implementing regulations for Section 504, also require recipients to take the following steps: appoint a Title IX coordinator, adopt grievance procedures for filing Title IX complaints, and notify interested parties that the recipient agency does not discriminate on the basis of sex.
We have just summarized the cross-cutting statutes that apply to recipients of federal financial assistance from the Office of Justice Programs, the Office on Violence Against Women, and the COPS Office. Again, these cross-cutting statutes are Title VI, Section 504, Title II of the ADA, the Age Act, and Title IX. We will now look at the program statutes that are unique to the Justice Department. The program statutes contain non-discrimination provisions that apply only to recipients of funding from the Justice Department. These provisions prohibit discrimination on the basis of race, color, national origin, sex, and religion in federally assisted programs, not only in the delivery of services, but also in employment. The program statutes are the Omnibus Crime Control and Safe Streets Act of 1968, as amended, or Safe Streets Act, the Juvenile Justice and Delinquency Prevention Act of 1974, as amended, or the JJDPA, and the Victims of Crime Act of 1984, as amended, or VOCA. The Safe Streets Act and the JJDPA have special requirements for recipients that we will discuss in a moment.
The principal program statute that the Office for Civil Rights enforces is the Omnibus Crime Control and Safe Streets Act of 1968, which is known as the Safe Streets Act. The non-discrimination provision in the statute is as follows. No person in any state shall, on the ground of race, color, religion, national origin, or sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under, or denied employment in connection with, any programs or activity funded in whole or in part with funds made available under this chapter. There are certain aspects of this law that require close reading. First, notice that the protected classes in the Safe Streets Act are broader than those covered in Title VI. Title VI prohibits discrimination based on race, color, and national origin. The Safe Streets Act does the same, but adds two additional protected classes, sex and religion. Second, notice that the Safe Streets Act not only prohibits funded agencies from discriminating in the delivery of service or benefits, but it also prohibits discrimination in employment. Third, just as with Title VI, the Safe Streets Act uses the language of program or activity to indicate that all of the operations of a funded organization must abide by the prohibitions against discrimination. Finally, as the statute states, it does not matter how much federal funding an organization receives. As long as an organization receives any federal financial assistance, it must comply with the non-discrimination provisions in the law.
The federal implementing regulations of the Safe Streets Act include a requirement that some recipients produce an Equal Employment Opportunity Plan, or an EEOP. An EEOP is a report detailing a recipient's workforce cross-classified by race, sex, and national origin in 8 major job categories. The report compares the demographics of the recipient's workforce in each of the major job categories to the demographics of qualified employees in the relevant labor market. And then the report identifies any underutilization.
Whether a funded agency has to produce and submit an EEOP to the Office for Civil Rights for review depends on a number of factors, including the type of organization the recipient is, the number of employees the recipient has, and the amount of the award the recipient receives. For more information on whether your agency has to produce an EEOP, go to the Office for Civil Rights website. Follow the links for EEOP. An online wizard will help you understand your agency's EEOP obligations.
The Juvenile Justice and Delinquency Prevention Act adopts by reference the civil rights obligations of the Safe Streets Act. This means that recipients of funding under this statute also must not discriminate in the delivery of services or in employment based on race, color, national origin, sex, and religion. It also means that recipients of funding under the JJDPA must also comply with the EEOP requirement of the Safe Streets Act.
Federal regulations implementing the Juvenile Justice and Delinquency Prevention Act require state administering agencies that receive funding under this statute to do the following: appoint a civil rights coordinator, establish grievance procedures, ensure the compliance of subrecipients with the EEOP requirements, and cooperate with all civil rights investigations of the Office for Civil Rights.
Another program statute that the Office for Civil Rights enforces is the Victims of Crime Act, which is commonly known as VOCA. The non-discrimination provision in VOCA is as follows: no person shall, on the ground of race, color, religion, national origin, handicap, or sex, be excluded from participation in, denied the benefits of, subjected to discrimination under, or denied employment in connection with any undertaking funded in whole or in part with sums made available under this chapter. Notice that VOCA's non-discrimination provision is similar to Title VI and the Safe Streets Act, with two differences. First, it expands the protected class so that the statute not only prohibits discrimination based on race, color, national origin, sex, and religion, but it also includes the additional protected class of handicap, which subsequent statutes refer to as disability. Second, VOCA uses the unusual word undertaking. At the time of the passage of VOCA, the Supreme Court limited the meaning of the words program or activity in Title VI, which Congress later amended to restore the original broader meaning. So, in drafting VOCA, Congress had to use alternative language. In the end, the term undertaking means the same as our current understanding of program or activity. That is, the non-discrimination provision of VOCA applies to all of the operations of an organization receiving federal financial assistance.
The Office for Civil Rights has prepared additional training segments available online on the following topics. What are the standard assurances and how does the Office for Civil Rights enforce civil rights laws? What are the civil rights obligations of state administering agencies? What obligations do recipients of Justice Department funding have to provide services to limited English proficient persons? What laws affect funded faith-based organizations? What civil rights protections do American Indians have in programs funded by the Justice Department? And what are the obligations of funded Indian tribes?
For more information on the Office for Civil Rights, you may write us at the Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice, 810 7th Street, Northwest, Washington, D.C., 20531. You may also telephone us at 202-307-0690 or contact us by TTY at 202-307-2027. You may also submit a question to the Office for Civil Rights by email at askocr@ojp.usdoj.gov. You may also visit the Office for Civil Rights website at www.ojp.usdoj.gov/OCR.